My name is Mary Vandenack, founding and managing partner at Vandenack Weaver LLC. I'm going to be your host today as we talk to some experts on the issues of incapacity. On today's episode, I have Rachel Truhlsen of Truhlsen Elder Law of Nebraska, Monte Schatz, a partner here at Vandenack Weaver, and Emily Pattison, also here at Vandenack Weaver. Between the group of us, we do a significant amount of estate planning and particularly dealing with some elder law issues. And incapacity isn't necessarily just an elder law issue. It can affect younger individuals too, but that's a little bit of the focus today. So Rachel, can you just talk to us about what incapacity planning is in general?
Right. In general, that would be planning for a period of time where you could become incapacitated, whether you've received maybe a dementia diagnosis or have some other type of illness that is impacting your ability to make decisions. It's important to put a plan in place. And that would look different depending on whether you're going to, say, be at home or whether you're going to be in an assisted living facility. But assuming that you're at home, you may want to put a plan together that would help you, say, pay your bills and do grocery shopping for you. You should have some power of attorney documents in place, a financial power of attorney document, and also a healthcare power of attorney document, so that you have people ready and on your team to make decisions for you if you're no longer able to do that. If you need to have people come into the home to help you take care of the home, whether that's doing laundry, whether that's doing some housekeeping, or even just minor house repairs so that you can stay home for as long as home is the safe place to be. It's just putting that plan in place ahead of time so that we're not reactive when there's a crisis situation.
And the key there really being plan ahead, because the people sometimes don't think about the incapacity planning as part of estate planning, but that's really a mission critical part of the whole process. So one of the things I like about your focus and approach is you really look at the whole picture. This isn't just about legal documents, but this is making sure you're ready for anything. And I feel like COVID really raised the level of awareness in a new way for a lot of clients. So Emily, can you just talk to us a little bit about what incapacity is? And I think there's a difference between diminished capacity and diminishing incapacity.
Yeah, absolutely. So diminishing capacity is a little bit more of the initial stage when an advisor or an attorney thinks that the client or the individual is starting to show signs of impaired decision-making, or not just being able to understand the nature of what it is they're signing or the legal implications of a document. At that point, though, when somebody has diminishing capacity, they're still legally able to make informed decisions. They just may need the assistance of an advisor or somebody else who can help them along the way. Diminished capacity, on the other hand, though, is when an individual has their intellectual abilities completely impaired, whether that's due to their illness, a condition that impairs their decision-making, an injury, or they just simply lack the ability to make those informed financial and medical choices.
So Monte, who should ultimately be making the call on a client's capacity? Is that something we as lawyers do? I know I used to teach fitness classes, and people would come up and ask me about their knee injury, and I'd suggest that they see an orthopedic physician or a physical therapist because I was just a fitness instructor. I know that I don't have any training in neuropsychology or something like that. So I always wonder, what is the role of the attorney? I mean, who should be making this call?
Like so much of the world, when you get into estate planning and then estate and trust administration, it really needs to be a team approach, because what we get into is really a combination of medical capacity and identifying issues medically, which is done by the medical professionals, such as it may be a neurologist if it's, some type of internal brain issues or something that needs to be diagnosed that's organic within the person's biological makeup, or it may be a psychiatrist, it may be a psychologist. And then you have to marry those concepts with what you learn from the medical testing and see how that looks in determining legal capacity issues, which not only looks at the the biological or medical aspects of it, but how does that affect that person's decision-making skills to take care of him or herself as a person, as well as to handle their own finances. So it's really a combination of both. What I always like to do, it's kind of a simple legal formula. I always say legal capacity, determination of legal capacity is a derivative of what you learn from the medical incapacity assessments first.
Thanks, Bonnie. So then let's talk about a little further on that, what role the lawyer plays in evaluating capacity. Again, I'm obviously not trained in psychology, but it's sort of like if I see somebody, like I might be signs of depressions, but I get them to the right person, right? But since we're not really trained in that, are there any tools available to kind of assist us with what we should be looking for? Because clearly we don't want to have a client who's not competent signing a will, for example, right? So to the extent that we're evaluating it to determine whether we should make a referral, what should we be looking at? Are there tools?
So
I'm sorry, I was asking Emily on that one.
Okay.
I'm sorry.
He can answer too, he would know, but the American Bar Association does put out a capacity worksheet for attorneys. It's pretty comprehensive, so it goes over a whole host of questions that you can ask a client if you feel like there is diminishing capacity issues, or if you have questions about whether or not they're able to understand the nature of the documents that they're about to sign. One of the things though in the elder law practice especially is the need to look for undue influence. So if you have a client that comes in and you feel like they're making decisions about their estate plan or they're signing documents that they may not want to be doing, that's something where you need to be on the lookout and separate them and talk to them and have a candid conversation about, is this what you want to do? Do you understand what you're assigning or what it is that you're giving away, or the authority that you're giving over to somebody else? And that's incredibly important for attorneys to look for.
So let's say, like Rachel spoke earlier on about sort of the need to make sure we're doing that advanced planning, but people don't always do that. So sometimes they're getting close to, I've had clients in, early onset dementia, and a lot of times they still have, Monty made that distinction between legal and medical capacity. And so they may still have the capacity to execute documents. There's various standards, and we won't go into the details of those today, but different attorneys have different approaches documenting. And if you have, Monty, what are your thoughts like on the pros and cons of videoing when you're having clients sign trusts and wills?
Could you repeat that last question again? I'm sorry.
Well, some people recommend that you videotape trusts and wills. Do you think, what are the pros and cons of that?
Yeah, well, that's a great question. Really, it's a judgment call on the part of the attorney as he gets to know the client that they are drafting documents for. And the things that I look at is if I particularly, as we all know, capacity isn't at a set stage. It can be fluid. There's times, with dementia, people can have total capacity. There's, it's the old adage of there's good days and there's bad days with these type of clients, especially when you're talking about dementia, particularly the Alzheimer's type. So if I'm into that stage, then I'm going to, then what I would lean toward doing a video. And I look toward asking a few basic questions, generally, what day of the week it is, and the kind of the standard for determining whether a person has some testamentary capacity, which ironically, of all the different types of legal capacity, has the lowest threshold, lower than a contractual capacity and so forth. That being said, though, I will ask them, it's the old adage, do you know what your bounty is? In other words, do you have some idea what your assets are? And do you know who the objects of your bounty are? Who do you want those to go to? And so after I ask the generic questions of the day and the week, sometimes who's the president of the United States, and some, broad general knowledge facts, then I go into the specifics about asking, can you tell me about what your assets are and so forth. And usually when you do that, that's really going to enhance the written documents that you've signed. That being said, the risk is if the person doesn't do well in that and the video comes out as somewhat, the client may not look that lucid and so forth, that may just be another that may be another thing to be introduced in evidence where they can attack the validity of the will or the trust due to lack of capacity.
So the real answer to that is a video can be supportive, but if you do have doubts about a client's capacity, then an evaluation is probably in order, because the video is going to create evidence of the fact you probably shouldn't have had that execution done. So Rachel, if you don't have a video or it's just not your practice, what other best practices could you engage in to just ensure the validity of, verifying the client's capacity and helping avoid challenges proactively?
Right. Well, and what I do in my practice is I take the time to visit with a client, and a lot of our clients in our firm, we have very well-established relationships with. So if I have a client who I've had a relationship with for quite some time, I know what's normal for that client and what's not. And so if there's a behavior that seems inconsistent with typical prior behavior, then I won't prepare documents that would be inconsistent with what their wishes would have been earlier. If it's a new client, then I'm very cautious about who I let guide the conversation. And I tend to address all of my conversation and all of my questions and answering directly to the client. And if I'm suspicious at all that they're not either properly replying to my questions or giving proper answers, then I don't prepare documents that for someone who doesn't seem to understand what the process is about.
And when you're saying that, and I'll just direct this one to Emily, if you have clients show up and daughter A is there and wants to be in the meeting, well, mom needs me in the meeting, and she starts answering the question, what do we do in that situation?
That's a great question too. And I've certainly had that come up when I've met with clients before. I typically try to be as collaborative as possible, where I do allow family members to come into those meetings. I think it helps with the general ease that the client feels just meeting with an attorney and going over documents that pertain to their estate plan. But yes, if you have a family member who's only answering or starting to get a little bit more of the feeling that they're running the meeting, I've asked them to step out where it just needed to be a meeting between me and the actual client so that they can clearly articulate what their wishes are. It may not be the most comfortable of situations, but I just try to reiterate that the client relationship is between me and the individual whose documents I'm drafting, and it's very important to make sure that their wishes are spelled out in those, not the wishes of their children or their other family members.
And Rachel, you and I spoke in another episode on the whole collaborative planning process. And you were speaking earlier to kind of the new clients. Does that collaborative planning process come into play if you've had a longtime advisor that's in the mix and you're newer to the client, or in general?
I think if you're saying, a client has come to me and has involved their investment advisor, for example, right at the very beginning of the process, then typically the financial advisor may have some general background information about the client and have information to share as far as their investments and their assets, and even wishes that they've discussed specifically with the financial advisor. And again, that's where the collaborative process is really important in the estate planning realm, is that oftentimes you're seeing your financial advisor more frequently than you are your lawyer. And if there's issues in the family, whether it's family dynamics or whether it's needing to use assets to pay for long-term care, your financial advisor is going to have that information more readily than the lawyer. So oftentimes the financial advisor or other professionals can provide some background information as far as the history of the client and what their wishes may be. And so we take that all into account when we sit down to visit with the client.
And so earlier in our conversation, you talked to us about kind of the importance of preparing for the possibility of incapacity. Do you have kind of a checklist of this is the items that we should make sure are taken care of so that we have our affairs in order for the client?
Sure. One of the first things I want to make sure that people have in order are their power of attorney documents, because more than likely those are going to be used fairly readily when we have someone with incapacity. So we want to make sure that we have a healthcare power of attorney in place and also a financial power of attorney in place. Make sure we've got a primary agent and a successor agent on both of those documents. And then make sure they have a will in place so that they've designated where their assets are going to go upon their death. If they have a revocable trust, say they did fund or create a revocable trust during lifetime, we want to make sure that we have the assets funded, or we have the trust funded and the assets retitled to that revocable trust. If they have any assets that are beneficiary driven, whether they're retirement accounts or life insurance, we want to make sure that those beneficiary designations are up to date. I have a lot of clients, or at least a handful of clients, who still have deceased parents as beneficiaries on their life insurance policies. It's not uncommon to find that. So we want to make sure we get those updated so that they are current and reflect their intentions and are consistent with their estate planning documents. Again, if there's any long-term care planning that we need to do, whether that's an option for long-term care insurance or even just asset protection strategies, if we have some time to do some asset protection, that's a conversation that we may want to have at that point too.
So Emily, when is a guardianship in order?
So a guardianship is, and Monty can also kind of agree with this statement, it's sort of the option of last resort. So if you have not executed a power of attorney and there is a client who has that diminished capacity where they can no longer make those decisions for themselves, and there's not a document in place that says who will be their agent, then a guardianship is really going to be your only option at that point. It's much more time intensive. You have to go through the court process, you do pleadings, you file documents, and then whoever wants to be the guardian, they're the one that has to go through this whole process of proving that they're the most appropriate individual to serve in that capacity. Typically, a guardianship is associated also with a conservatorship. So not just who's going to make decisions for the health and well-being of this individual, but who's going to be handling their financial resources and who's going to be the custodian of those things.
So are those two going to be one and the same, Emily, or are those often separate? The guardian and the conservator?
They can certainly be separate. There are times where you would just need one or the other. I've had clients where they really don't have a lot of financial resources, so a guardianship is going to be the primary alternative for them, and a conservatorship is just not something that's needed. Conversely, you can have it where somebody has a lot of finances and they appoint a conservator, but they don't necessarily need a guardian.
And Monty, you get involved in a lot of disputes regarding guardianships and conservatorships. And so I'm kind of curious because what goes on in that field has gotten really interesting in terms of fights between children and things like that. So when somebody calls you, I need to be named my guardian's mom, how do you evaluate whether that's really needed and whether the person calling you is the right person to handle it? And who's your client? If the daughter is calling to name you, I want to be named guardian for my mom, who's the client and how do you decide if you should pursue that for her?
That's always a slippery slope you have to walk down when you go into these, because as you stated, Mary, you might have a child or some other third party that goes in and says, I think that Joe Smith or Jane Smith needs a guardianship. Okay, well, then you got to do the assessment of whether there's, and then if it's to the point of where it's litigation, you really, if that individual child comes in and thinks, and they're not the designated guardian, then you better identify that you're representing that individual, quote, interested party, and that you're going to be disputing the guardianship. And the tools that I like to go through then is at that point, I want to see the degree of familiarity with the person who's going to contest the guardianship and or conservatorship. Why are they doing it? What type of evidence do they have that either the existing guardian should be replaced or the guardianship should be removed? And frankly, I'm as much as I hate to admit it, you have to be somewhat skeptical of your own potential client and those things, and you really got to vet that out before you jump into this thing, because it may not be a good outcome, and you may be representing the person in the black hat, so to speak, sometimes. But yeah, it's just critical you identify who your client is, and like I said, you got to go through that whole process of how did this guardianship come to be, and if you're disputing it, why should it be removed? Do you think the protected person has a level of capacity that can take care of their own matters, or alternatively, if they're protesting who the current guardian is, and so frequently, and in conservators so frequently, that's usually a battle, of an intra-family battle between brothers and sisters, and then it gets down to is the current person who's really the appointed guardian or conservator the wrong person, or is this a legacy of bad family feelings? You got to really vet all that information out.
Yeah, and that can be an area I was wondering at one point, has things changed, or is it just as we've been around longer? Because we've really seen, and you particularly seem to attract some fairly interesting cases, which is why I threw that question at you on the fly. So thanks for your great answer. So, Rachel, when we do know that somebody's incapacitated, what can we do to help them? What can be done to help them?
Yeah, I think it's really important to keep them engaged as much as possible, because people with memory issues or dementia issues that may contribute to incapacity, they need to socially engage with people. That keeps their brain functioning, and it just is helpful to them all around. You also want to assist them with medical appointments, because they're not likely to remember information that's important to provide the doctor, and they may not remember information that's important to provide to the family so that they can be supported. So if the family can come alongside them and take them to medical appointments and be a part of that process, that's really going to help that person moving forward. And also encourage the person with a capacity to be part of any decisions related to their care. It's important to include them in that process and empower them to make those decisions, because they are the important person in the middle of all of this decision making, and they need to be part of that process as long as they're able to make those decisions for their own benefit. And then again, like we talked about before, be sure you've got a plan in place to help them with their finances when that's necessary. Help them with the healthcare decision making and any other matters that they may need help with down the road. So having that plan and being proactive rather than being reactive is always the best plan moving forward.
So I want to thank each of you for participating today, and that's all for now.